next matter before the court this morning is Landmark 2 Limited Liability Company versus East Ohio Gas Company. Both sides will have 15 minutes to present oral argument. If you're the appellant, you may reserve up to 5 minutes for rebuttal. Please don't use the names of any victims or minors as we are recording this at Windows Zones, the court's YouTube channel. I don't think that's relevant, but it's good for everyone in the room to know at each time we call the case. If you wish to reserve any time for rebuttal, you can let me know when you get started. I'm keeping the clock. You can also reference it on the wall, but it just helps me with the pacing of the questions and the argument so that I can let you know if you're into your rebuttal time. We've read the briefs and we're ready to proceed when you are.
May it please the court, my name is Greg Kroc. I represent the East Ohio Gas Company, which does business as Dominion Energy Ohio, or DEO. I would like to reserve 3 minutes for rebuttal, if I may.
Certainly.
This lawsuit involves the operation of DEO's Energy Choice Program, which is a program that is approved by and governed by the Public Utilities Commission of Ohio. Specifically, the lawsuit involves what happened to the gas that was inserted into DEO's pipeline system in accordance with this Energy Choice Program by the local producers, who are entities that own and operate gas wells in the vicinity of the pipelines. Now, what was supposed to happen to this gas is governed by a tariff that is approved by PUCO. The PUCO-approved tariff required that DEO provide a credit for all of that gas. All of the gas that came into the pipeline system, DEO had to give a credit to the entities that had contract to purchase the gas from the local producers. Those entities are defined in the Energy Choice Program as choice suppliers. DEO contends that it complied with the tariff. It gave those choice suppliers credit for 100% of the gas that was inserted into the pipeline system. So DEO does not deny that if there was gas injected into the pipeline system by local producers, they deserve to get paid. But the choice suppliers got a credit for that gas under this Energy Choice Program, and if there is some shortfall, it's the choice suppliers who have to make up that payment. Now, the local producers do not deny that the DEO tariff required DEO to give a credit to the choice suppliers for all of the gas. But the local producers' position in this lawsuit is that DEO simply didn't do so. The DEO only gave credit.
Counsel, yeah, let me interrupt you because, I'm reading these briefs and everything, I'm just trying to figure out, you're saying obviously that the PUCO has exclusive jurisdiction, and I'm trying to figure out why this isn't just a mathematical determination, why somehow they have to interpret to determine how you get 100%, so you're interpreting rules to determine if you've got 100%? I don't understand that.
Right. I guess I would say there's a couple things, Your Honor, factually and legally. From a factual standpoint, we certainly did try to simplify things and explain the reconciliation process as succinctly as possible. But it's not necessarily quite that simple. I mean, to understand the process does require an understanding of how the gas comes into the system through meters, right, and how it's measured. And then how the pooling system works, how each choice supplier might have multiple meters and multiple points and multiple customers to supply it to. So it is a little bit more factual, is trying to figure out, okay, how the gas came through the system, how it was received, how it was transported, and then how the reconciliation process works. There's storage facilities, there's imbalancing. So factually, it might be a little bit more sophisticated than a simple mathematical analysis.
No, but I'm sorry.
I'm sorry. But secondly, the General Assembly has given PUCO the exclusive jurisdiction over all claims that involve services and that services were provided improperly. So even if this were something that were more simple and less sophisticated, that doesn't necessarily mean PUCO doesn't have jurisdiction. It's not PUCO has jurisdiction over service-related disputes that we deem to be complicated or sophisticated. Even if it's something that a trial court theoretically could do, it could get up to speed and it's not the most sophisticated pipeline dispute, that doesn't mean that PUCO doesn't have exclusive jurisdiction.
Well, I understand that, but I guess I'm still not understanding, you're saying that they have the jurisdiction because with the reconciliation, they're going to have to interpret the reconciliation, that's what I'm just not understanding.
Absolutely, how the
What kind of interpretation?
Well, I mean, how the nomination, there could be a dispute about what was nominated. The nominations are made on an electronic billboard, right? So there could be some dispute about, what the nomination was and where the gas was supposed to be delivered. There could be a simply measuring issue. It might be.
And I'm sorry for interrupting you, but I don't want to lose my thought on that, and that's what I'm thinking. If it's just an issue of nomination, how is PUCO, or I hate to say that because that sounds terrible, so I'll say PUCO. How does PUCO have any more expertise than anyone else to do that?
Well, but I mean, like I said, is to try to figure out why. Let's assume there was a deficiency. There could be any number of reasons why. It could have been some error in the nomination process. It could have been an error in the reconciliation process. These meters aren't infallible, right? Maybe there was actually some type of meter problem with either the meter taking the gas into the pipeline system or the meter that measures the gas that exits the pipeline system. So there are a number of different reasons, Your Honor. But there's also an important factor that I didn't mention. The DEO tariff has a limitation of liability provision in it. And it says that as long as DEO operated reasonably and in accordance with industry standard, it is not liable for errors or mistakes that it made. So, even if there was some type of error or some type of issue within the DEO pipeline system, a decision has to be made is, how does that limitation of liability provision come into play? How does it affect what exposure might exist for DEO? That certainly is within PUCO's expertise. And I think we cited cases in our brief just in those exact circumstances when the tariff has a limitation of liability provision, that is a reason, an additional reason why PUCO would have exclusive jurisdiction.
I'm sorry.
You make a statement.
Now, one of the errors that the court made was simply applying the wrong standard. And I'm not sure that the court even got to the inquiry you had, Your Honor, Judge Carr, because in this situation, what the court did was assumed for the purposes of the motion to dismiss for subject matter jurisdiction, assumed that all the facts were true. So if you read the actual order that the court entered, the court said, if the alleged conduct is true, it would fall outside of the scope of the reconciliation process that is ordinarily governed by the DEO, tariff, and PUCO. Well, that's not the appropriate standard. There's no dispute that if a conversion occurred, the trial court would have damages to apply jurisdiction to apply the damages. We don't deny that. The local producers may very well get their day in the Court of Common Pleas at some point in time. But first, the question is, did a conversion occur? Was there an error in the pipeline system or the reconciliation process that somehow excess gas existed? Right? Because if the DEO tariff if everything worked as it was supposed to, gas came into the system, it was transported in the system, and it worked out of the system, and the reconciliation process worked the way it was supposed to, and that, quite frankly, the way it was required to, under the DEO tariff, there would not be any excess gas available for conversion. So, in this circumstance, that shows that when the court said, if the conduct were true, the court did not do an analysis of looking at the DEO tariff, looking at the allegations in the complaint and comparing them and said, is it possible to find out how the gas moved, how the reconciliation process worked, and whether or not there was excess gas that could be converted? Is it possible to do that analysis without also examining the tariff, what the tariff requires, and how it's supposed to work? The court never did that analysis. What the court said was, assuming, is that the allegations in the complaint are that there was excess gas and it was converted, and PUCO does not have exclusive jurisdiction to assess damages and conversion. So that statement shows that the court never even got to the very issues we're talking about here.
Thank you, Counsel. I do want to ask you, because I assume you're still aware that the motion to dismiss is still pending, requiring there being a final appeal of order.
Correct, Your Honor.
And can you explain to the court how you believe this matter is final at this point?
Certainly. While we will acknowledge that you can find old cases in Ohio that state that
You say old cases, what about the new authority they submitted in the Supreme Court case last year? Do you think the Stewart case, am I remembering correct, the Stewart case in this matter?
Yeah, the Stewart case did not involve subject matter jurisdiction at all.
Okay.
That was a motion to dismiss, for failure to state a claim under a statute that allegedly provided immunity to certain healthcare providers. So if you read the facts of that case, they didn't talk about summary judge or subject matter jurisdiction.
You found newer cases that say subject matter jurisdiction is a final appeal of order?
No.
You complain about the older one, but you have some new ones that tell me here's some new cases.
We do not, Your Honor. What we found is since 1998, when the statute that defined final orders was broadened, and that provisional remedy section was added, we have not found a single case that actually applied that new section to an order denying a motion to dismiss for lack of subject matter jurisdiction. So while you might find new cases that still say it in dicta, and I think the local producers cited one in their case, they said, well, it's long known that personal jurisdiction and subject matter jurisdiction, the orders denying a motion to dismiss on those bases are not appealable. None of those cases actually involved a motion to dismiss for lack of subject matter jurisdiction.
Of course, being on the bench for 25 years as an appellate judge, sometimes the reason is because nobody has appealed.
Exactly.
Yeah,
Yeah,
but
so-
because maybe they're not a final appeal order.
Right. But I will tell you, Your Honor, Judge Stevenson, in response to your inquiry, the amendment in 1998 is critical because the purpose of that amendment was to recognize that there should be more circumstances in which common sense dictates that we don't wait until the end of the case for a final resolution on all the issues. That while it's true that we want to avoid piecemeal litigation, the provisional remedy section recognized that there are more circumstances where fairness and judicial efficiency just require an immediate appeal on certain issues. And it's important to keep in mind that subject matter jurisdiction is very, very different. It's not even like personal jurisdiction or venue. Subject matter jurisdiction means that nothing that actually happened in that proceeding exists. It's a nullity. It was void from its outset.
Excuse me, why wouldn't you remedy a prohibition?
Pardon?
Why wouldn't you remedy in a prohibition?
Well, our understanding is we're not allowed to pursue a writ of prohibition if we have an adequate remedy at law, and we believe
But
that
the whole point is you may not, so.
Right, but I mean, our point is, we still have that option available, but I don't think I could have done it the other way. I couldn't have lost on a writ of prohibition and then come here to this panel. I've got to do it this way, because I think this is a final appeal order. If this court were to disagree, then maybe we can pursue a writ of prohibition, but I think that's the way we had to pursue it. But I would say that subject matter jurisdiction is more like double jeopardy. Subject matter jurisdiction means not just that you have the right to avoid being hailed into a court, but you shouldn't have to participate in a court where anything is a nullity. Keep in mind that a plaintiff that loses can raise on appeal that the court didn't have subject matter jurisdiction because waiver and estoppel don't apply. An appellate court can say, even if the parties agree that jurisdiction exists, no, jurisdiction didn't apply. So subject matter jurisdiction is different. There's just no reason to force all these parties to go through an expensive, costly, time-consuming class action and then have the entire thing done as a nullity. That's what the provisional remedy section is intended to address in that amendment.
Counsel, can I ask you one question before you have to speak?
Sure.
What is the status of the conversion claim right now? The status of the conversion claim?
It's on, the status of it meaning it's,
Wasn't it dismissed?
oh yes, I'm sorry. That claim was dismissed. I apologize.
All right, that's what I wanted to make sure. Thank you.
May it please the court, my name is Stephen Webster, and I represent the appellees who include, I will call them the landmark plaintiffs, probably for ease of reference. And with me is Marshall Pitchford, who is our co-counsel. He is a counsel table. The first question really is, I heard counsel use that phrase, the first question, with respect to the substantive argument, but the real first question is, does this court have jurisdiction to hear this appeal at all? And counsel says they don't have any other cases that overrule or distinguish the cases that we have cited that clearly say unequivocally, in multiple appellate forums, fora that a motion to dismiss personal jurisdiction or subject matter jurisdiction, of course, even a substantive claim is just not an appealable final order. And that makes sense because, well, counsel refers to judicial efficiency of allowing some of these things to percolate up through the appellate courts. Were the court to rule in their favor on the final order, you would get the exact opposite of judicial efficiency. Every defendant would file a motion to dismiss for lack of subject matter jurisdiction or lack of personal jurisdiction and take an appeal. And
Well, but you still have to meet the requirements
You
of
do.
the statute.
That's right.
And so I think maybe there might be a hybrid, middle ground, that not every subject matter or personal jurisdiction one, but some may be. Here you got a class action that, from their point of view, they could say, and I'm sure they have, could be 10 years before we get final resolution of it. And then I have to put all the expenses and payment and everything out, and people have to go through everything for all that length of time and then get a resolution that I can find out that the court didn't even have subject matter jurisdiction?
And Your Honor, I apologize, I don't remember the precise case, but when you talked about the expense associated with that, one of the cases that we cited in our brief, the court did address that and said, just the costs, the high costs of litigation are not a reason to allow these appeals. And the fact is that if there is not subject matter jurisdiction, that can be taken up after an actual final order is entered, and it could be addressed by this court or by the Supreme Court. And so, while there are circumstances where an interlocutory appeal, an order will be deemed to be a final order, I'll say it that way instead. Those usually involve situations that the language that is used sometimes is that the bell cannot be unrung. And the cases that they cited are really the prime examples of cases in which the bell cannot be unrung. Double jeopardy. This case is not a case involving double jeopardy, and the constitutional right is the right not to be tried at all. And so you can't unring that bell.
Counsel, but it's interesting that wasn't always recognized. It's only been in the last few years that you could appeal a double jeopardy.
I understand that, and that's a good decision. I started out my career as a public defender, and if you file a motion to dismiss saying, I've already been tried for this, that's absurd that you wouldn't be able to appeal that. So I'm glad that's been rectified. The other cases that they run through, most of them are criminal cases, and they include the defendant who is subjected to forced medication. I'm sorry, the defendant who was subjected to forced medication is State v. Muncie. The double jeopardy was State v. Anderson. Denial of an indigent criminal defendant's application for expert assistance is State v. Powell, another case they cite, another criminal case. A non-criminal case is Thomason versus Thomason, which is when the trial court unqualifiedly denies admission pro hac vice to someone's counsel of choice. And that was in a civil case, Your Honor, that was not a criminal case. All of these cases involve a situation, and that's the Thomason language, quote, the bell cannot be unrung, unquote. This bell can be unrung. They can litigate the case. If they win, and they sound very confident, then there's no need to appeal. That's judicial efficiency. And if they lose, then they can have the subject matter jurisdiction issue addressed. The cases, they don't have any cases that overrule or distinguish the cases that we have cited, whatever age or vintage they are. And the notice of supplemental authority that we filed, admittedly, it was a case involving immunity and not a motion to dismiss for lack of subject matter jurisdiction. But one would think that if there were a type of case that would qualify as a final order, it would be immunity. That's more like double jeopardy, I would suggest to the court, than the situation that we have here. But it doesn't even rise to the level of a constitutional right like double jeopardy is.
Looking at the statute 250502, do you believe that a class action case is a special proceeding?
Your Honor, I think under the definition of special proceeding, it was not available before 1853, which I think the year is. And so I think it is a special proceeding. It's interesting that that statute, if I may say, is a little complex in some respects, but the courts have had no trouble applying that statute and the Ohio Constitution to issues of lack of subject matter jurisdiction and lack of personal jurisdiction.
Look at that statute, how do you think this order fails to be a final order for 25052?
Well, first, it didn't, well, there are, of course, a number of subsections, Your Honor. And so, it is a special proceeding, I do believe, that's correct.
If it's been a substantial right, I would think we would tend to agree with that.
If it is a rule of procedure that entitles a person to enforce or protect, I don't know that they are enforcing or protecting. You know, we are using the class action vehicle as a means of moving this case forward. I don't think that rule is enforcing or protecting their interests with respect to this case. So, for those reasons and based on the case law that we cited, we do believe that that is the law. That is the law in Ohio. Your Honor, I'm sorry, Judge Carr, you had asked counsel whether the case was going to focus on the reconciliation process, and there is a case called Marsh v. Howard Trucking, which we cited, and I'm trying to find the reference to it. What the court is the Second District Court of Appeals, and what the court there said was, quote, "What is a simple question of fact does not overwhelm the capacity of the court to render judgment on contract rights so as to deprive the court of subject matter jurisdiction," unquote. And Judge Croce hit it right on the head, and this is a simple case. It's, what does the meter say? So the gas comes from the producer, it goes into the pipeline, Dominion has a meter, and there are records of that. Some amount of it is nominated by the choice suppliers for their customers. Dominion confirms the nomination, and then that gas is sold to the consumers. The choice suppliers get paid, they pay the producers. It's the delta between what went in and what came out to the consumers through the choice suppliers. And it really is, I think as Judge Croce appreciated, just a simple math problem.
Let me ask you, so you don't think there would be anything that, in regard to like number of hours that East Ohio Gas could hold the gas in their pipelines, or any issues in regard to, you know, how the meters function that would be of statewide importance, for instance, in the provision of utility services, any of those type of issues?
No, Your Honor. Our view of this case is it really is an arithmetic. It's not just math. I mean, it's arithmetic. It's adding and subtracting. And if you take the amount that goes in, and you take the amount that the choice suppliers nominate, and that's confirmed, and then it's sold, and then they get paid for it, that's the difference, and that's the missing gas. That doesn't impact in any way what the PUCO does with respect to the tariff. And in fact, the way that the assignment of error number 2 is phrased is interesting, because what they assert is that the PUCO maintains exclusive jurisdiction to resolve claims, quote, involving, unquote, the services that DEO provided. That's not the law, because there are many cases involving tariffs or rate schedules, or the involvement of the PUCO, where they are allowed to proceed in the Court of Common Pleas, because they don't impact the regulatory regime. So to answer Your Honor's question, no, this is not that type of case. And in the Marsh v. Howard Trucking case, the court did put some guardrails, the Second District put some guardrails. And they said, so long as the findings of the court with regard to the conduct called in question do not directly place in review agency orders or alter the responsibilities that exist under the regulatory framework, the court may proceed to a just resolution of the controversy. In other words, the trial court. And so this is not a case where we anticipate or even have pled that we are directly placing in review agency orders, and we do not seek to alter the responsibilities of DEO with respect to its operation of the pipeline that is subject to the tariff. And sorry, I skipped over assignment of error number one, but I did want to get to that question that you raised because the case law is right on point. The other case, Your Honor, I think this is the closest case that we have to this case. It's State Ex Rel Dayton Power Light Company versus Riley, Ohio Supreme Court, 1978. And the situation there was that Dayton Power and Light had entered into contracts with consumers. And the PUCO approved those contracts. And what the contracts did, I'm not sure if there was a fluctuation in supply, and so this is why they approached it this way. They had a contract, and Dayton Power and Light would store the gas for these customers. And then when they needed it, they could draw down on it so that everyone knew it would be there. A customer filed a class action saying that Dayton Power and Light had breached the contract, and the trial court denied the motion to dismiss for lack of subject matter jurisdiction. They then filed a writ of prohibition, a petition for a writ of prohibition with the Ohio Supreme Court, and the petition was denied. And the Ohio Supreme Court said the Public Utilities Commission is in no sense a court. It has no power to judicially ascertain and determine legal rights and liabilities or adjudicate controversies between parties as to contract rights or property rights, end quote. And so, well, it might have been a better idea to file a petition for a writ of prohibition challenging jurisdiction. That case, the Dayton Power and Light case, seems to foreclose that option. And it should also foreclose the option that they're trying to exercise here. The first assignment of error is that the trial court erred by accepting as true the allegations in the complaint. And the trial court was required to consider the entire record and not just the complaint. Well, they submitted one piece of material, one documentary material that was extraneous to the complaint, and that was the tariff. And Judge Croce expressly addressed the tariff in her ruling. She said, well, first of all, in the course of ruling on the motion to dismiss, the Ohio Supreme Court has held that in cases involving public utilities, jurisdiction is not conferred based solely on the pleadings. So clearly she was aware that she had to consider the entire record, and then in fact she went on to do so. The trial court expressly considered, this is my words, not Judge Croce's, the trial court expressly considered the tariff submitted by DEO. That's in the motion to dismiss, the order on the motion to dismiss at pages 5 and 6. I mean, there are two paragraphs, I believe, where she directly addresses the tariff that they attached to their motion to dismiss. And third, DEO expressly told the court, quote, the court need not conduct any evidentiary hearing on this matter because the DEO tariff is clear, end quote. So with respect to assignment of error number one, Judge Croce recognized what the law is with respect to subject matter jurisdiction. She expressly considered the only piece of documentary evidence, which is the tariff, that DEO submitted. And DEO did not ask for an evidentiary hearing or conduct evidence on subject matter, conduct discovery on subject matter jurisdiction. Instead, they told the court, basically, this is all, I'm over my time. If the court has no further questions, I'll take a seat. Thanks.
Thank you, Counsel.
Just a few quick points. First, as far as the the final order, the law is clear and the statute is clear that provisional remedies can exist in both civil and criminal proceedings. Special proceedings can exist in both criminal and civil proceedings. And the Supreme Court of Ohio has ruled that that statute applies equally to both. So the fact that this happens to, we're invoking the final order in that statute under a civil proceeding as to a criminal matter is irrelevant. The statute applies equally.
Counsel,
I'm sorry.
I'm sorry, I keep on thinking of all these questions. But 250502 later on does talk about the grant or denial of a class action, is final and appealable. Does that have any impact here at all?
I don't think so, because we haven't gotten to the point whether the class has been certified. I think that's a different provision. I think the class action we referenced was to invoke the special proceeding part, but I don't think we can honestly say at this point in time that a decision has been made on whether to certify the class.
Thank you.
But the only, substantive arguments is for, I wanted to point out that the council referenced two cases, the Marsh case and the Dayton Power case. Those are contract cases. Okay, in those cases, the plaintiff who brought the lawsuit had a specific contract with a utility, and the court examined the contract and said, I can make a ruling in those cases under your contract. I'm not really looking at and interpreting a tariff like this situation. Well, in this situation, right here, the local producers do not have a contract with DEO. DEO did not contract to purchase any of their gas. We don't have any contract with them whatsoever. Their claim is that the gas they inserted into our system, somehow we exercised unlawful or improper control of it in a manner that was wrongful. Well, under the DEO tariff, the DEO tariff states that when that gas enters a meter that is designated to a particular choice supplier, title passes and title is owned by the choice supplier, not by the local producer. In fact, the choice supplier has to indemnify DEO against any disputes over the title. So the argument that this gas exists and that it even could be converted, that mere fact can't happen unless there is a violation of the tariff. And that's what it comes down to in this case. In order to find exposure for DEO, the trial court is going to have to find that we violated the tariff. They don't have to interpret it. Any allegation that we violated the tariff, regardless of how simple or how complicated it is, that argument is something that's within DEO's exclusive jurisdiction.
Counsel, thank
Thank
you.
you.
Thank you both for your presentations today. The court will take the matter under advisement. We will issue a written decision, which will be mailed by the clerk to all parties to this appeal, as well as posted on the Ohio Supreme Court website. Thank you.
Thank you.